The U.S. Supreme Court on June 27, 2025 issued a landmark ruling sharply curbing nationwide injunctions sweeping court orders that block a policy everywhere, not just for the parties in a case. In a 6-3 decision, Justice Barrett writing for the majority, the court held that such universal injunctions likely exceed the power Congress gave federal courts. The decision stems from President Trump's controversial executive order to end birthright citizenship under the 14th Amendment, but its effect goes far beyond that one issue. By limiting judges' ability to halt policies nationwide, the ruling is widely seen as a major victory for the Trump administration and its agenda. Nationwide injunctions have been used in recent years by courts around the country on immigration, public health, education, and more to suspend federal actions for all Americans, even those not involved in the lawsuit. Justice Coney Barrett's majority opinion races the history of equity and finds nothing like a universal injunction in the founding era or in early U.S. law. As she writes, Congress never gave courts such sweeping power in the 1789 Judiciary Act or elsewhere. In practical terms, the court now says judges may only enjoin enforcement of a policy narrowly, usually just for the parties before that court, not for the entire country. Barrett emphasized that courts do not exercise general oversight of the executive. When an agency acts unlawfully, the remedy must stay within the case's scope, not become a nationwide veto of policy. Nationwide injunctions have been the norm in the last decade. The nonpartisan Congressional Research Service found that 86 nationwide injunctions were issued during Donald Trump's first term, and at least 28 in President Biden's first 2 years. Indeed, as President Trump noted, he faced more injunctions than the entire 20th century combined. Democrats and Republicans alike have used such orders. For example, courts blocked a Trump travel ban to the U.S. by issuing nationwide relief, and during the Biden-era courts nationwide halted some Trump environmental rollbacks. Supporters of the injunctions argued they were necessary to fully protect rights across the nation. But critics, including Trump and his allies, had long complained that any single judge could paralyze a policy for everyone. This ruling sides with the critics. The Supreme Court's decision came in the context of a birthright citizenship case. On his first day back in office, President Trump signed an order to end the automatic U.S. citizenship granted by the 14th Amendment to anyone born here. He declared without waiting for Congress that if the mother was in the country unlawfully, or if a non-citizen father wasn't a lawful permanent resident, then a baby born on U.S. soil would not be a citizen. Opponents point out that for over a century, the 14th Amendment has been understood to guarantee citizenship to all born on U.S. soil, regardless of parent status. Within days, several lawsuits were filed by 22 states, immigrant rights groups, and individual families challenging the order as unconstitutional. 3 different federal judges in Washington, Maryland, and Massachusetts each issued nationwide injunctions blocking the order. In other words, each court said, you cannot enforce this rule anywhere in the United States. The government then appealed to the Supreme Court, asking that those injunctions be limited to the actual plaintiffs. In mid-March, the Trump Justice Department asked the justices to narrow the injunctions so they would apply only to the 28 states and individuals who sued, rather than the entire nation. The administration warned that the flood of nationwide injunctions had reached epidemic proportions since January, and that they had been blocking key policies on border security, international relations, military readiness, and more. However, rather than immediately granting or denying relief on the birthright question, the Supreme Court in June chose to address a more fundamental issue. Are these universal injunctions even allowed? That question has been brewing for years. In past writings, members of the court, from Justices Alito to Sotomayor, have criticized nationwide injunctions, and the president and his allies had publicly attacked judges who issued them, even talking about impeaching a judge over it. So the court took up the pending birthright appeals. Not to decide the merits of birthright, but to set a new rule on nationwide injunctions. On Friday, the court limited the use of nationwide injunctions. In the majority opinion, Justice Barrett focused on history and the law. She found that if Congress had intended one judge to have sweeping power over the entire country, surely they would not have let it lay idle for so long. In fact, she noted, courts historically did not use that tool. Barrett concluded that under the original Judiciary Act and modern rules, federal courts lack authority to issue injunctions that go beyond the litigants before them. The opinion states plainly, a judge may enjoin an unlawful executive action as to the parties, but the answer is not for the court to exceed its power to. In practical terms, the Supreme Court allowed the current injunctions to stand for the plaintiffs who sued, but prevented those orders from carrying nationwide. Justice Barrett granted the administration's request to narrow the injunctions blocking the birthright order, but only to the extent that they were broader than necessary to provide complete relief. In other words, the lower courts can continue to block the rule for the plaintiffs, the specific states, and people who challenged it, but they cannot stop enforcement everywhere else. The court did not rule on whether ending birthright citizenship is constitutional. Instead, it paused Trump's policy for at least 30 days and sent the cases back to lower courts to figure out what happens next. During that time, the federal agencies were allowed to issue guidance and prepare for implementation, meaning the birthright ban could partially go into effect after the grace period unless blocked again. The ruling split the justices sharply. The three liberal justices Sotomayor, Jackson, Kagan dissented together. Justice Sotomayor, speaking from the bench, warned that the majority was ignoring the Constitution's promise of equal protection. She wrote that the president's order and the court's decision made a solemn mockery of the Constitution. In her dissent, Sotomayor cautioned that this new rule could threaten all sorts of rights. No right is safe in the new legal regime the court creates, she wrote. Today it's birthright citizenship. Tomorrow, any administration could try to seize guns, restrict religious gatherings, or otherwise act unlawfully, knowing courts might not be able to enjoin it for anyone outside a lawsuit. Republican leaders hailed the decision. At the White House, President Trump called it a monumental victory for the Constitution, the separation of powers, and the rule of law. He and Attorney General Pam Bondi celebrated that courts can no longer veto all of his policies. Bondi quipped that some district judges had been acting like emperors by issuing nationwide bans on executive actions, and she declared that bipartisan problem of excessive injunctions has ended today. The president specifically noted that, thanks to this decision, his administration can now move forward promptly with many policies that had been wrongly enjoined on a nationwide basis, including his effort to end birthright citizenship. Indeed, Trump remarked it was an amazing period, noting he'd faced injunctions far beyond anything seen before, more than the entire 20th century. Me, he exclaimed. In his post-ruling press conference, President Trump even listed some of those policies that had been blocked by injunctions. He said the administration can resume actions on sanctuary cities, refugee resettlement, and limiting federal funding for transgender surgeries, among others. We have so many of them, Trump said. I have a whole list. In short, any program that a federal judge halted for everyone might now be implemented except where specifically sued. Republicans believe this shift will greatly expand executive power and order stays in force in most places unless each challenged state or individual gets relief in court. Not everyone rejoiced. Democrats condemned the ruling as a serious setback for judicial checks on the presidency. Congressional Democrats said the court had dealt a loss for the judicial system's check on executive power and vowed to keep fighting Trump's birthright citizenship ban. Immigrant advocacy groups also sprang into action. Casa de Maryland, which earlier obtained a nationwide injunction against the birthright ban, rushed back to court seeking class action status to try to block the order not just for its members but for all similarly situated people. Their concern is that without nationwide relief, vast numbers of U.S.-born children could be stripped of citizenship in states whose governments didn't intervene. In fact, officials from 18 states had argued to the court that Trump's request was remarkable and would render hundreds of thousands of American-born children deterritoriality on birth if allowed. Some analysts note that lower courts will now have to sort out exactly how to rework past injunctions. Judges may tailor relief more narrowly or require class-wide suits to block a policy entirely. Attorney General Bondi suggested the administration will follow the new 30-day pause and wait for further rulings. We're going to follow the law. We'll discuss it after the litigation, she said. Meanwhile, several states that had sued are preparing to press their cases at the Supreme Court on the merits of birthright citizenship, which Justice Barrett's opinion left open. Bondi even predicted the justices most likely will decide the birthright issue itself in the next term. The long-term impact of this ruling is broad. By neutering the nationwide injunction, the Supreme Court has effectively boosted the power of the executive branch. The Trump administration and future presidents will find it harder to have entire policies blocked by a single judge. Instead, opponents must bring suit on behalf of themselves or their states. This could make it easier for the government to implement controversial actions unless challengers mount class-wide or multi-state litigation. For example, consider any new rule on immigration or health care. Under the old regime, a single federal judge could halt it everywhere. Under the new rule, that judge can halt it only for the plaintiff in that case. Trump cited policies on sanctuary cities, refugee admissions, and transgender health care as having been blocked nationwide. Now each would require a separate legal challenge in each jurisdiction. In the past, both Republican and Democratic presidents often targeted nationwide injunctions to advance their agendas. Now that tool is largely gone. Critics say this means an unchecked executive could enact sweeping policies, knowing courts will only address the harm to specific plaintiffs. Supporters argue it prevents unelected judges from dictating policy to the whole country. Birthright citizenship illustrates the stakes. Before this ruling, one judge in Massachusetts had stopped the order everywhere. Now the rule could take effect in many states, unless those states sue individually or join class actions. Advocates are gearing up for such litigation. For instance, Casa de Maryland is seeking to represent all U.S.-born children born to undocumented parents in a bid to restore universal relief. If a class is certified, that might allow a broader injunction. But otherwise, the government can move ahead in places that haven't been blocked. Meanwhile, lower courts must decide if, say, only Massachusetts residents or the Maryland plaintiffs. themselves are barred from enforcement. This fragmented approach will define how much of Trump's birthright ban can actually be implemented while the Supreme Court ultimately considers its constitutionality. More generally, any future policy, whether on climate change, voting rights, immigration, or national security, could see a very different path through the courts. The broad case or controversy framework emphasized by the court means that nationwide protections are no longer automatic. The administration and Congress might respond by quickly rewriting laws to tighten executive authority or by giving clear instructions on standing. Meanwhile, states and advocates may push Congress to legislate directly on contentious issues rather than rely on uncertain judicial remedies. In sum, the Supreme Court's June 27 ruling marks a major shift in the balance of power. By restricting nationwide injunctions, the court has handed President Trump's administration a significant edge. Policies it enacts are less likely to be halted for all Americans by the action of a single court. This change was immediately branded a monumental victory by the president and his allies. Opponents warn it weakens the judiciary's check on the executive and could leave many Americans without a federal remedy if their rights are violated outside a lawsuit. The coming months and years will show how lower courts apply this decision and whether Congress or the courts will find new ways to address nationwide legal claims. For now, President Trump's agenda, including the fight over birthright citizenship, has gained new momentum as the judiciary's reach has been curtailed.